In the cryptocurrency sphere is a community of ardent crypto nerds, expert traders, financial and legal aides alike who've collectively come to be known as the XRP Army. A band of blockchain heads who've stood against the powers that be in a trial termed the cryptocurrency trial of the century. Welcome back to Make Money Online. If this is your first time on the channel, please consider hitting that subscribe button and turning on post notifications. You can join our free Discord group via the link in the description for daily signals and a community of like-minded traders and investors. And now you can also support us on Patreon, and we have a special offer for our first 100 members, only $9.99 for VIP access on Discord, which gives you exclusive benefits far beyond the free features. Be sure to check out the links in the video description and in the pinned comment. The trial between Ripple Labs, its chief executive officer and executive chair, and the United States Securities and Exchange Commission has taken a lot of twists and turns. Many had thought an inquiry, especially those on the SEC side, would not last for more than a week, but it's grown to span almost half the entire year, charging Ripple Labs and its executives on the claims that the crypto, under the supervision of these two officers at the helm of affairs, had illegally sold these XRP coins to the general public, was never really the issue. The bulk of the altercation between the SEC and Ripple is that the SEC didn't act based on fair judgment. As stated on its official website, the mission of the SEC is to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. The SEC strives to promote a market environment that is worthy of the public's trust. However, the Commission has been going contrary to all of that by way of this lawsuit. As such, it has sprouted the anger, or we might say awoken the titans, within the formidable XRP community. While these XRP proponents are aware that there is a likelihood of these two executives making huge profits off the sales of XRP, and they are perhaps enriching themselves, their partners, and team members at the detriment of an ordinary investor like you and I, one of the primary reasons the XRP community went after the SEC is considering the Commission's negligence to the very people they've sworn to protect. This has led to the XRP community filing a counter-motion to intervene in Ripple's fight against the SEC, claiming that the regulator doesn't represent them. A motion that was first denied because it wasn't filed properly. As we can see down here in the comments section of this tweet, one of considerable importance by yet another Ripple official, its CTO, David Schwartz, all of this is happening on March 16th, only for the John Deaton pioneered litigation on behalf of the XRP community to be accepted a few days after, bagging another win for this asset class. And precisely 2 weeks after that denial, on the 30th of the same month, it says here by one of the XRP Army's very own favorite XRP reporters, Yuri Malkin, that the SEC's attempt to prevent the XRP community from intervening in the SEC versus Ripple case has been rejected by the court. A request to intervene can now be submitted. Reading through that piece, it goes on to elaborate more on the topic mentioned above in the following wordings. The U.S. District Court in New York has greenlit John E. Deaton, who acts on behalf of the XRP community, to file a request to submit a motion to intervene in the legal battle initiated by the SEC against blockchain giant Ripple Labs and two of its high-profile executives, Garlinghouse and Larson. The request should be submitted by April 19th. In case the plaintiff, the SEC, has any response papers, those must be filed by May 3rd, according to the order. In conclusion, it hinted that the official response of the court will be announced on May 17th. The XRP coin is in itself one of a kind, and the first of its kind, which is why the crypto-based fintech startup keeps registering streaks of wins in the ongoing class action lawsuit. 3 days ago, Judge Netburn granted the SEC's motion for additional statements during a recent hearing, however dismissing all requests by the SEC for the blockchain-based payment settlement firm to provide post-indictment documents, along with the company's lobbying effort, which is unconventional for a common crypto platform. Judge Netburn clarifies that Ripple's motion for a fair defense focuses on the SEC's activities, adding that it's not about Ripple's knowledge before selling these supposed unregistered security tokens. Neither was it about the fintech firm's negligent behavior. In her words, Judge Sarah Netburn had the following to say: Ripple focuses on the SEC's failure to fairly inform the market of the Commission's state of mind as to whether XRP qualifies as a security. It's not clear that such a defense even requires a defendant to act in good faith. These comments are significant and clarify that the responsibility still lies with the SEC and indicates that the SEC's actions and inactions regarding the XRP coin could also be questioned. The judge also made it clear that should the XRP token be considered a security, the SEC is only just saying so after about 8 years of the asset's existence. Is the SEC only just finding this right now, or does it mean that the SEC has also been negligent in their duties? According to one of the court proceedings, the SEC has refused to provide answers to exchanges asking the commission to give a clear-cut definition of what the XRP token was in actuality, since the regulators had earlier hinted that the XRP coin was not a currency back in 2019. However, there had been some assumptions that the SEC would try to settle the litigation with Ripple, mainly based on a lack of fair notice from the commission, which would, in turn, attract a fine from the SEC and Ripple. Alas, we would have to deal with the news of the Ripple vs. SEC lawsuit for the next couple of weeks, as the court has granted the U.S. financial regulators a 60-day extension as requested by the commission. The court has granted the SEC the go-ahead to usher 5 more affidavits, while objectively denying the 6th one on the basis that it was an unripe deposition. Following the magistrate's decision to extend the discovery date by 60 days, the court's order that dismissed the SEC's inquiry into Ripple's memos regarding its lobbying effort was most welcomed by the XRP community. The court also denied the SEC's request to search records pertaining to Ripple's general counsel and deputy general counsel for privileged information. On the court's denial spree, the court went on to debunk the presentation of all Ripple's documentation that predates the complaint. Going even further, Judge Sarah Netburn stated that, as discussed in the court's earlier opinion and order denying access to Ripple's privileged communications, Ripple's fair notice defense centers on the activities of the SEC, not its behaviors. In accordance with the initial order, the court allowed for a window of opportunity for the SEC to reopen the said motion in the event that Ripple raises the beliefs or relies upon its privileged communications to bolster the fact notice defense that had the potential to save the industry from the SEC. The court order dated Tuesday, June 15th. In the same vein, Ripple's lobbying efforts regarding the status of XRP are not relevant, and the burden of production outweighs my relevancy argument. James Filan, a federal prosecutor who is also a crypto proponent, happens to be pro-XRP, and who also made the court order known to the general public on his Twitter page. At Filan Law, I suggest you guys follow this guy if you haven't already. On his Twitter page, he wrote, "This is a good sign for the fair notice defense. Judge Netburn has made clear to the SEC yet again that the focus of that defense is on the activities of the SEC and not on Ripple." And as another U.S. attorney, who's also an ardent XRP supporter, Attorney Jeremy Hogan would have it, I'm getting a vibe from the judge that she's digging the fair notice defense. Ripple's FN defense is about the SEC's state of mind, whether XRP is a security. This takes away a little sting from the 60-day extension. According to this particular attorney's estimations, the SEC's request for an extension of the discovery date earlier this week will most likely extend the entire proceedings back by an equal number of days, 60. That would mean, quick calculations, summary judgment sometime in December, January. Absent a settlement, this case is going to end in early 2022. Regulatory clarity, which has been the issue from the get-go, has prompted many doubts regarding whether the SEC has given fair notice and if XRP is a security. Matters of such and more would soon be clarified as the United States Congress just recently announced a digital asset working group. But in the meantime, all we can do is wait to see how it all plays out. Now is about the best time to buy into this digital asset right before it takes flight. So stay vigilant, keep investing in suitable investments as we look forward to the moonshot that would change our lives for the better. Thank you for watching today's video. If you enjoyed it, please consider hitting that subscribe button and turning on post notifications. You can also support us on Patreon via the link in the description, and don't forget to join our free Discord group as well. If you have any questions or comments, let us know, and we'll see you next time.